Okay. Well, hello, everyone. Welcome to our World Court of Human Rights Coalition meeting of 27 March 2024. We are recording today's meeting, and I appreciate your participation in the meeting. We're going to be welcoming Professor Robert K. Goldman as our expert speaker, and I will introduce him shortly. But first, we'll give just a brief update for the coalition, and I'll ask Mark Ottinger, who is our World Court of Human Rights design team leader, about an upcoming international law event in Burlington. And for the sake of time, I would ask everyone to identify yourself with your names and any particular affiliation, organizational or otherwise, that you'd like to mention in the chat. We will have Professor Goldman will be talking for probably around 20 minutes or so, giving his expression of interest and concerns over creation of a World Court of Human Rights. And then we'll have time certainly for questions. So let me begin by, let me actually put this on speaker view. Okay, so I'll begin by just giving you literally about a 1-minute update for the coalition. I've spoken with Dr. Dinakpan Chobo of JGIE Global Justice Intelligence Eyes the other day, and we had a really great conversation about preparing an agenda for this coming year to move the coalition forward. And we talked about things such as creating regional representatives, that is, representatives in various parts of the world who will represent the court. So if any of you know of people in Africa, in Asia, the Americas, Europe, etc., who would be interested in as volunteers representing the coalition and advancing the court, please email me, please let me know. Also, we are hoping to build up volunteer staff, and there are some interested individuals who are even on this call today who might be interested in some of those volunteer positions. And of course, fundraising and development efforts will be crucial for us to really promote and advance the education with the global public for the coalition. And we're also waiting to hear back, which is usually in June, but sometimes can take more than a year, from the Economic and Social Council of the United Nations, their non-governmental organization branch, for consultative status that will allow us to attend UN meetings and hopefully interact with the 3rd and 6th committees of the UN, which deal with human rights matters and legal matters. So that's just the brief update, and we can, if anybody has questions about the coalition or where we're at, we can deal with that at the very end of the meeting today. So now I'd like to turn it over to Mark Ottinger to tell us a little bit more about the international law event that he is heading in Burlington, Vermont, coming up in a few days.
Thank you, David, and nice to meet everybody. And Professor Goldman, it's great to have the opportunity to listen to your remarks. Thank you. The Vermont Bar Association is having its mid-year meeting on Friday, and I chair its International Law Committee. We have been given 90 minutes, which we have divided into 3 30-minute segments. The first is being presented by former Vermont Lieutenant Governor Molly Gray and her colleague Nathan Virag, who is an attorney who represents the Association of Africans Living in Vermont. The AALV acronym is a bit of an anachronism, since AALV now serves more Asians than it does Africans, given the evolution of the new American population in the state of Vermont. A very, very small percentage, but it's growing. And so Molly, our former Lieutenant Governor, is now Executive Director of the Vermont Afghan Project. And she is, spoiler alert, looking for some volunteers to assist, attorneys to assist with dealing with housing, dealing with other, civil rights, if you will, anything that the newly arrived Afghan population really needs. They're going to talk about that for half an hour. Then one of my other colleagues and the Vermont Poverty Fellow are going to discuss SIJ petitions, which are special immigration juvenile petitions, sort of arising out of the unaccompanied minors at the Mexican border, but having application for other minors who are in, let's say, legally infirm positions here. And then I'm going to do a presentation about a couple of things, including sort of the history of public international law leading up to the proposed World Court of Human Rights. And I'm also going to touch on issue spotting for Vermont lawyers on issues like international contracts, something a little bit private international law for that matter. So that's the presentation that's coming up. We're really excited about it, and looking, I managed to get the opportunity to showcase a tiny bit about the World Court of Human Rights, and I'm hoping also that it will be actually an opportunity for members of our committee, who number about 50, and other parties with the Vermont Bar Association interested in international matters, to essentially get together and to brainstorm about the work that we do for the Bar Association, which is pretty active. So I'll stop there. Thank you, David.
Thanks, Mark. I do have a quick question. Will the event or any part of the events be either recorded or be to see asynchronously, or even to watch over Zoom?
I believe that it will be. It's going to be, it's from a sort of proprietary standpoint, it's a VBA product. I think that I can probably get a portion of the video, at least that portion dealing, say, with public international law, that they would release for, under a fair use doctrine or something like that. I will double check on that and follow up as necessary.
Excellent. Yeah, and especially if you're able to highlight the World Court of Human Rights in any section, even if it's just a couple minutes, having that video could be useful. So,
and I mean, we're going to start all the way back at some of the beginnings of, U.S. Civil War, when some of the early law of war was developed, and through 1899, and then through the League of Nations, and we're going to race through that entire thing and end with a fairly good portion of time talking about the statute of the World Court of Human Rights. I think I'm pretty shameless about it, David.
Okay, good. Thank you. Well, I appreciate all your work too over the last really almost 12 years now, working on advancing the World Court of Human Rights. So thanks, Mark. Okay, well now to our special guest speaker, Robert K. Goldman, who is professor of law and Lewis C. James Scholar at American University Washington College of Law. He's also faculty director of the War Crimes Research Office and co-director of the Washington College of Law's Center for Human Rights and Humanitarian Law. He was a member of the Inter-American Commission on Human Rights from 1995 to 2004, and was that body's president from 1999 to 2000. From July of 2004 to August of 2005, Professor Goldman was the former UN Human Rights Commission's independent expert on protection of human rights and fundamental freedoms while countering terrorism. In 2008, he was elected a commissioner and member of the executive committee of the International Commission of Jurists. And since 2018, Bob, I'll call him Bob, even though his official name is Robert, was elected president of the International Commission of Jurists. And I can tell you, I was a law student of Bob's in his human rights law and international humanitarian law classes many years ago, and can personally attest to his expertise and dedication to the global rule of law. So I really sincerely appreciate, Bob, you being here with us today and speaking about a potential future World Court of Human Rights. So
sure.
Thank you so much.
Thank you very much. And it's very nice to see David again. And he's gotten a little older. Not to say anything about myself, but this is a topic that I have great interest in. I've had conversations with David before. I was familiar with what Manfred and Martin were doing. Both of them I know quite well and have worked with in the past. And I've reviewed the draft Lucknow Treaty. As I told David that I support the general idea, but I have certain reservations that I'm going to go through with you. And it deals most particularly with the possibility of concurrent jurisdiction with pre-existing regional human rights systems. As many of you know, we have in the Americas, in Africa, in Europe, and a very well-established human rights system. There's an incipient one in parts of Asia, but we have nothing for the Middle East, quite frankly, other than some of the countries that may be parties to the Banjul Charter. And obviously for China and so forth, there's nothing covering them. I've had a lot of experience in international litigation. Prior to becoming a member of the Inter-American Commission, when I was on the boards, many of the advisory boards of Human Rights Watch back in the mid-'80s and Washington Office on Latin America, International Human Rights Law Group, I was involved very much, for instance, with the Southern Cone countries of Latin America that were under military dictatorship, Chile, Argentina, Uruguay, Paraguay, and so forth. And since I had lived in Uruguay as a Fulbright after college, but between law school, I kind of took up the cause of victims when the military staged a coup effectively, and was quite a brutal dictatorship. So I began filing cases before the Inter-American Commission and the UN Human Rights Committee, dealing with torture and other kinds of systemic violations by the military dictatorship in that country. The Inter-American system, as many of you might know, the Inter-American Commission was created in 1960 and began receiving complaints and blah. But the American Convention on Human Rights, very much patterned on the European, but not entirely the same, entered into effect in 1979. And that replicated the pre-existing Inter-American Commission and so forth with its 7 members. And then it created the Inter-American Court of Human Rights. And since that time, the system has remained intact. It is not like what Europe did with Protocol 11, abolishing the European Commission on Human Rights, which I think and many Europeans think was a disaster to have just a single, without a filter like the Commission, because of many of the countries like Turkey prior to Russia's being that the systemic problems that you had in former Soviet dominated republics. They look much more like cases from the Inter-American system. So I've had experience on both sides of the aisle, litigating cases as a petitioner on behalf of victims and so forth, and then as a member for 2 terms of the Inter-American Commission on Human Rights. So I'm very familiar with those procedures and the like. One has to realize that there are major differences in standing requirements, for example, between Europe, the Inter-American system, African, and then the UN system, that is the Committee on Civil and Political Rights. Within the Inter-American system, we probably had the best and most liberal standing requirements that you didn't have to have the consent of the victim. And when the American Convention had entered into effect, the vast majority of people within South America were living under military dictatorships. And part of the emblematic practices of these countries were disappearances. We had that, obviously Argentina was the worst, but they existed in Uruguay, they existed in Chile, they existed up in Guatemala and so forth. You obviously can't have the consent of the person who has disappeared and so forth, which would be, and because of the reason the Inter-American system entering into effect when it did, in the kinds of cases that the Inter-American Commission was dealing with, facing these military dictatorships that had policies to violate human rights and then would withhold information or outright lie about what their practices was, that they developed a kind of jurisprudence that departed from the European. Because the Europeans, this was way before the Europeans let in the former Soviet countries and so forth, and it was more or less Western European democracies with well-established rule of law. Rule of law was either not very strong in most countries in Latin America, or in the case of the military dictatorships, it was clearly not respected because jurisdiction in many cases was transferred to military courts. So the commission began developing its own jurisprudence on issues like exhaustion of domestic remedies and exceptions to the exhaustion of remedies. The kinds of evidence, the reliance on the creation of presumptions, something you did not find within the European system at all. And as a matter of fact, I can tell you, when in the Turkish cases in the 90s and so forth, or in Russia, but particularly in Turkey, the European court was floundering. And frankly, they had to turn to the jurisprudence of the inter-American organs, the deal with disappearances and so forth. The standards of proof and so forth are different between the two. The Europeans have this absurd, beyond a reasonable doubt. That's a criminal standard. It has no place in a human rights treaty, in my view. So one of the reasons why I'm outlining this is to show you that there are substantial differences, even though they guarantee most of the same rights. There are major differences, and the jurisprudence reflects the realities of the particular regional system. The African system I know less about, but we're dealing with a lot of collective rights and so forth and so on. The UN Human Rights Committee has tended to track more the inter-American system because of the similar rights, like non-arbitrary deprivation of the right to life, as opposed to an exhaustive list and so forth under the European system. And all of the systems, as I said, have a variety of ritualistic, formalistic measures that you have to go through. All of them have the prior exhaustion of domestic remedies. But then again, you have to look to each of the systems because they have different rules that have developed for exceptions to exhaustion. And then you go and, for instance, within the Inter-American Commission, you file before the Commission. And the Commission has separated admissibility from the merits and so forth. Unlike Europe, there has to be an admissibility decision. And in the admissibility decision, it deals with all the, not just admissibility, but jurisdictional issues and so forth, the ratione persona, materia, time, so forth and so on, defines the dispute. And then once it's admissible, we have what is known as a friendly settlement procedure, which is extremely important. I was involved with, I think, no less than 15, many of them with Argentina, which were among the most creative solutions, that is, without further litigation, that gave rise to changes in law, rehabilitation of the memory of victims and so forth, compensation schemes for victims of the abuses. So this is a very important thing, which is not part of the statute, by the way, of your statute. So the friendly settlement procedure within the inter-American system is very well established, and that must be offered after the admissibility decision. If this does not work, then the Commission will issue an Article 50 report setting forth its conclusions of law, findings of fact, and so forth. And the Commission used to have the option, it does in cases like America, the United States, some of the English-speaking Caribbean members, in Canada that are members of the OAS, and consequently subject to the jurisdiction of the Inter-American Commission. But those states have not accepted the jurisdiction, that is, they haven't ratified the American Convention on Human Rights. So we have a dual system, if you will. And that is states that are parties to the American Convention, and then those are just parties to the OAS Charter, thereby subjecting and so forth these states to the scrutiny of the Inter-American Commission. But generally now, because of reforms and so forth, the individual victim or the representative takes the case to the Inter-American Court or the state itself. That's rare, but usually the victim will take something to the court. And there are three phases of litigation before the Inter-American Court. There's the preliminary objection. This is very much tracks International Court of Justice practice, that the state and states frequently do interpose preliminary objections and so forth. Once that is decided and so forth, you go to the merits. And then there's the third phase, the reparations. Frequently, reparations are collapsed into the merits and so forth. So you can see there is since 1979, well, the Commission jurisprudence since the 1960s, which has continued in the Inter-American Court jurisprudence. The European Court of Human Rights has been grinding out, and the previous commission, for 70-some years now. So you have a very vibrant body of jurisprudence and so forth within that. And the Human Rights Committee, of course, has been since it was those parties to the optional protocol and the commission actually deciding cases under the complaint mechanism. And I've gone into this because I want to show you that how difficult it will be if any draft, whether it's this Lucknow or it could be an alternative thing, attempts to have a concurrent jurisdiction with respect to pre-existing regional bodies. I support the idea of a universal court for the UN treaty bodies that have complaint mechanisms, the CAT, the ICCPR, the Economic Covenant, and whatever. They make recommendations. I think those things, we should have a court. And I could envision jurisdiction extending to countries that have are not parties to a regional human rights system. But I have grave reservations, both politically and, quite frankly, legal. And I say politically because, human rights treaty bodies, believe me, or if you're like the position I held on human rights and terrorism in the midst of the war on terror under the Bush administration, you're dealing with politics all the time. You're having to deal with that, and I've helped to draft international instruments like the guiding principles on internal displacement. You're dealing with states, you're dealing with other interested groups and so forth, and international organizations. And as I said, the statute appears, that is Lucknow, that it could take jurisdiction in here cases from the regional systems. And there are major drawbacks to this. Is if you're talking about concurrent jurisdiction, but the statute is utterly silent, even if it were to do that. At what stage? It says you have to exhaust, domestic remedies. But what are they going to use for exceptions to that? If it's a case that's going to come out of the Inter-American system, do they make their own rules, or are they going to be bound by those within the Human Rights Committee or the European Court or the African Court? That's just one major issue. And at what stage must an election be made? It's silent on this. Can I go and litigate before the Inter-American Commission? And if I am the petitioner and I don't like the decision, can I avoid going to the Inter-American Court? And then do I go to the World Court? The World Court just deals with issues of law. Will it be bound by what the Inter-American Commission found, or is it de novo? Or can I go to the Inter-American Court, litigate, I lose, and of course, for state parties to the American Convention on Human Rights, once you finish litigating, guess what? It is res judicata. In both the Inter-American Commission, the Inter-American Court, and the European Court have made very clear they are not fourth instances. Their job is not to cure bad internal decisions unless those decisions disclose that there's been a violation of the convention and so forth, the respective treaty bodies' convention. So do you get another bite of the apple after you've gone through the whole regional system? These are very, very difficult. How do you reconcile these particular things? Another thing which I found, and I was somewhat shocked when I read the Lucknow statute, is they don't deal with reparation. I don't see, knowing the kind, having been a litigant, and then, as I said, a judge effectively deciding cases, why anyone would choose to go before court that the only satisfaction you're going to be given is a stamped document that said, this country has violated your right to this, your right to that, and so forth. Let me give you an example. The jurisprudence within the Inter-American system, which I think is tracked fairly well by at least the UN Human Rights Committee, is that if they find that a state has violated a right, there's a duty to investigate, identify, prosecute, plus indemnify the victim. And there is a very extensive jurisprudence within the Inter-American system where you have disappearances, or you will have torture of a victim, and the victim either is so mentally or physically impaired, he or she can no longer work. And both in friendly settlements as well as decisions of the Inter-American Court, the most important things there are the scheme of reparations for the family, the loss of income, all sorts of other that parallel domestic general principles and so forth that on the kind of monetary damages that you have to continue to supply, money for the sustenance of the children until they get age 18 or 21. You've got to provide this, you've got to provide that. These are very, very important things. And quite frankly, this is more meaningful for many victims than the declaration of the finding by the Commission or the Inter-American Court in particular, that there has been a violation. So from a very practical matter, I would never advise a person, if they had the option at whatever stage, to go to a world court as opposed to the Inter-American system, when they have the possibility of getting compensation and so forth. So these are the problems that I see, and they're major problems. And many of these things would not become that apparent unless you have been a litigant, and you knew all of the stages. And the other thing is, as I said, what body of law? The statute is very, very skimpy on this thing. If you're dealing with a European case, are you going to be influenced by African jurisprudence, Inter-American jurisprudence? What is going to guide? And I can give you another very good example. One thing, I teach both, and I've taught IHL for 46 years. I was very involved with the introduction of IHL fact-finding at America's Watch, and then again at the Inter-American Commission and so forth. I've litigated cases and so forth involving this. And there is no common approach on the use of IHL by the major treaty bodies in the world. The European Court's jurisprudence is, well, I'll be charitable. It is contradictory, and it is at times, to me, incoherent. The Inter-American Court and Inter-American Commission in particular have been rather consistent and so forth, but it's not entirely the same as the UN Committee on Human Rights. What are they going to do? Are they going to fashion their own body of law? That is this world court, particularly if it comes out of one of these regional systems. It's not insurmountable, but what I'm just saying is these are sort of not, there's no commentary that I've seen, and you would have to need a commentary given the brevity with which it just mentions major issues that, quite frankly, one has to think about. And so let me leave it at that with just this. I clearly support something for the UN system. These people should, and victims, be able to file before a court that will have jurisdiction and so forth. But I think they should be able to award damages, just not cease and desist or a declaration of finding. I think where there is not a regional system, it may make sense to include that. But I am very skeptical about the concurrent nature, because that's all it could be, is concurrent, I would suppose, or you opt for one or the other, and over pre-existing regional systems that have proven, quite frankly, to be extremely effective over time. So I'm open to questions now.
Bob, thank you so much for this.
Yeah.
Your review of this draft statute and your concerns. One of the purposes I know that I got involved in the development of a World Court of Human Rights was to help develop a common world law so that we could sort of formalize human rights around the world, so that the regional systems, these differences would not be so substantial or so problematic. And I guess my question to you, to throw it back at you, since I respect your expertise, is to how would you, playing the devil's advocate, reply to your, I guess, two main concerns about the concurrent issue of working perhaps against what might occur in a regional system. So that's the first one, and perhaps the lack of compensation, which I think would be easier to resolve just by adding that, the award of compensation or redress in more detail into the statute. So I'll stop and with that, and then we'll go on to other questions.
Yeah, look, I'm a realist. You're not going to get rid of the regional systems. They're not going to disappear. They're very well entrenched. Litigants know them, and regions have differences, historical differences. The Banjul Charter, in terms of its emphasis on people's rights, it doesn't have a derogation clause, unlike the other three major treaties and so forth on the area. And I just gave you, out of I've written about the Inter-American system, how it was negotiated, in the realities. There's no margin of appreciation. I mean, this is a big thing. I mean, margin of appreciation, I never liked it. The European margin of appreciation. Those guys, what they do is they look at the merits of something and then they dismiss it, or they are overly deferential, in my view, to states and so forth. Probably if democracies had been ruling at the time of 1978 or so forth, when the American Convention, they may have adopted the margin of appreciation. But there was no way the Inter-American Commission and the Inter-American Court were going to give to a bunch of thugs like Videla and Galtieri and Pinochet and so forth a margin of appreciation. And so that has never been done. The Commission has never, other than adopting a fourth, it's not an appellate court, the system. You just can't come because you don't like a judgment where you have free access and you can litigate. So the reality is you're not going to get rid of these things. It would be nice to think, but there's no such thing, even when you look at the International Court of Justice. It's true in one case that they say they don't have stare decisis. But we do know that if the court, like in the Nicaragua case, when Nicaragua sued the United States during the United States' support for paramilitary and direct military activities against the Sandinistas. And the court and so forth declared that Common Article 3 to the Geneva Conventions was effectively a peremptory norm. They're not going to backtrack from that. But the ICJ is very clear, even there, it's not making world law. It is deciding disputes that binds only the parties thereto. And so there's much more, frankly, a precedent that has emerged in the regional systems than we have even, I think, with the International Court of Justice and so forth. So the reality is, you've got to accept you're not going to get rid of them.
Yeah, I don't see it as an issue of getting rid of them, but somehow incorporating them into a global judicial system.
Well, when you say a global, you can extrapolate. There's no question, very much like how you, in international law, determine general principles of law common to the world's major legal systems. There is major coincidence in various areas and so forth. And I have no problem in saying that there could not only be general principles, but there could be a clear-cut customary law at the universal level that is derived from regional practice. And a very good example would this be. One of the things that I did that has given me the most satisfaction in my career is I argued the first cases successfully, whereby the Inter-American Commission on Human Rights struck down the amnesty law in Uruguay. And then they struck down the Argentine due obedience and full stop laws. The Inter-American system led the way in particularly the Commission in the development of the legal theory of why amnesties were violative of the American Convention on Human Rights. And they required not only truth-telling, but the punishment of those state agents and so forth that perpetrated violations. That is now carried over to other systems. I mean, there's a pretty general view today, and even the UN has adopted it, that amnesties for serious violations of human rights and IHL are simply not valid. And so you could extrapolate something that began within the Inter-American system and so forth, carried over somewhat into Africa before the Human Rights Committee also has adopted. The Europeans have had less of this. But yes, I think you can deal with that, but I don't think there are going to be differences, David, because of regional realities, and that's the case.
Oh, sorry. Thank you, Bob, for that analysis. Mark, I'm going to get to you in just a second, but in the chat, there was a question from Hem Basapa, who wrote, how do you enforce any kind of law that does not have the approval of a nation's parliament or government? And secondly, you have mentioned about awarding damages. Who is going to be liable for it? The government at fault? The country that was responsible for a certain kind of development that creates the situation?
Well, the awarding of damages and so forth was states and the American Convention and certainly in the European Convention, African states agree that decisions of the court are binding. And just as the International Court of Justice, they're binding if the ICJ issues, they don't dictate to the state how they go about enforcing this. That's a matter of internal domestic law. There are some constitutional reforms that have occurred, for instance, throughout Latin America, where the included within it, I guess the word is the block of constitutional rights within the country, includes the human rights treaties. And the courts have interpreted that decisions and so forth of the treaty bodies have the force of law. They are legally enforceable. There have been other cases where you cannot get in federal states or whatever. This poses a difficulty. But there is the state, even if this has occurred, there's usually a lag time in decisions. In other words, a decision can be a determination against the state in ordering, for instance, of reopen the proceedings, identify and prosecute the perpetrator that may have, under the local law, a res judicata issue. This arose in Colombia, and the Constitutional Court dealt with it and interpreted it in a way that it did not run afoul of the constitutional prescription against reopening things that became, and so forth, res judicata. So there's governmental succession. It doesn't matter. The state is a party. It's not the government that's a party. If there's a decision, the state, it is their duty. How they go about doing it is their problem, but nonetheless, the duty is there.
Right. Hem, did you have a quick follow-up to that, or did that help answer your concern?
I'm wondering, I how you can go to enforce it, because the country may not recognize a certain character, or they may not agree. Then what are you going to do?
Well, if I understand you, certainly I can tell you in the inter-American system and so forth, if they've ratified the treaty, they have a continuing obligation. Does this mean that they always do it? The answer is no. I argued cases where, like in the amnesty case against Uruguay, we won it in 1992. It was not into the early 2000s, because of changes of government, the passage of time, that the Supreme Court, which had previously upheld the amnesty law under domestic law, then subsequently declared the amnesty law null and void. And that permitted the actions to take place in where military and so forth have been tried and have been jailed. The same thing happened in Argentina. The same thing happened in Chile. So it doesn't mean a court, yes, no court has, they don't have it's not a domestic court with the executive enforcing. You don't have that. But I can tell you in my lifetime, I have seen things that one would not have thought was possible. And so there can be a lag time. But what there is no question about, if you are a party to the treaty, and the treaty specifies, as the American Convention does, that the judgments are binding, then it's up to the state, however dualist or whatever, however the internal constitutional arrangements, they must undertake to comply with the judgment. And as I said, we had lots of trouble in the case of state agents who, for instance, benefited from an amnesty. And that had a preclusive effect at that time. Now, 20 years later, the court reverses the decision. They would go into court and they'd said, you know, there were like acquired rights. You can't set aside except. So the domestic legal system has had to work that out. That is a matter of domestic law. And it is a matter how the domestic law goes about receiving international law internally.
Great. Okay. Bob, thank you. Mark, off to you.
So there's a lot to respond to, and I know we don't have a whole lot of time. So let me make a couple of points. Number one, if the statute of Lucknow makes it appear that the vision is for a concurrent jurisdiction, then it's misleading. The concept developed by the World Chief Justices, who are basically the authors in the aggregate of the draft, contemplate appellate jurisdiction, not concurrent jurisdiction. Now, I understand that the regional courts purport to think of their decisions as being final and unappealable and so on, but the vision that the Chief Justices had, to sort of take an American sort of or US kind of analog, is that if you imagine the US Supreme Court essentially coalescing a jurisprudence that comes to it from primarily intermediate appellate federal courts, from the circuits, and that the idea of a World Court of Human Rights would be to essentially take appeals from the regional courts, or if there is no regional court, such as in Asia, have certain amount of original jurisdiction, and to essentially make a jurisprudence that was global in nature. When you think back to the creation of the ICJ, and you think about the idea of an international court of human rights, which was talked about at the time, this is a world court of human rights. And the wording is very intentional and very by the Chief Justices. Because if, the ICJ may deal with a fishing treaty between the US and Canada, and that's a very specific local thing. I understand that regional human rights treaties also reflect some degree of regionalism. What the Chief Justices, I think, would say is that there are some aspects of human rights law that are universal, that are indeed worldwide, and that the jurisdiction of this World Court of Human Rights would be limited to those types of human rights. And there's talk about whether environmental rights and whether animal rights and so on would fall within them. I think what the Chief Justices would say is, no, we're talking about, basic human rights such as food and shelter and fundamental health care and freedom from violence and so on and so forth, and that this court would deal with class actions, not individual actions. The idea of not contemplating reparations is, on the first instance, that's what the Chief Justices said, that can be handled at the domestic level. There are questions as to whether the domestic level would be fair and unbiased and so on and so forth. But as David says, if the solution is you need to have reparations, you can add that on without any trouble. It does, I think, make the court much less nimble. But the Chief Justices were very clear: no reparations, no criminal prosecution. This is about the universal concept of of human rights. And so you get into conversations about, well, but what about genital mutilation, as an example? It's kind of a cultural, regional thing. The sense of the Chief Justices is that there are certain things about human rights in particular that are universal, and that therefore that are inherently global in terms of law. And that's what they were trying to design. The politics, certainly a problem, and I mean, maybe I should stop there, but I mean, I also agree with Professor Goldman that as far as, how do you enforce things? Well, if the country is a signatory to the treaty, then it agrees that the treaty becomes domestic law and it's enforceable in the domestic courts, as Professor Goldman points out. But in the absence of a country being a signatory to the treaty, the decisions of a World Court of Human Rights would still be instructive. They would still be influential. The phrase naming and shaming has been talked about. The ubiquity of information with the current, sort of everybody has an iPhone in their pocket, instantaneous worldwide information, with some exceptions such as controlling the media. Russia would be an example. That's more of the concept that is contemplated. Exhaustion of remedies, absolutely. I don't think a World Court of Human Rights is contemplated as taking a decision from a part of the world that was covered with a regional court, unless and until that regional court had addressed the issue and had ruled upon it. And then again, the World Court would take it up on an appeal basis, not on a concurrent basis. That's the concept that they envision. And but your comments, Professor Goldman, are very, very valuable, and I appreciate everything you've said. There's obviously a lot of stuff in terms of Article 20 that deals with the substantive law. I'm not sure I would call it thin. What it basically essentially does is it trusts, you talk about commentaries and how the law should be applied and so on and so forth, or I think that's what you're implying. And I think the Chief Justices, being inherently judicial officers, feel that it is the role of the courts to flesh out the jurisprudence. Of course, commentaries and annotations and all of those secondary and tertiary materials will develop over time. But what is envisioned is a singular court to be a final court of appeal from the regional courts to adjudicate an area of law that is intrinsically universal. I'll stop there.
Bob, you have a quick reply to that, because we have certainly at least one more question.
Yeah,
Rebecca, shoot.
well, thank you for clarifying the at what stage that it's not concurrent. Quite frankly, I think this really creates a lot of problems, because the notion of you get another bite of an apple, I do not see many governments wanting to say we've already subjected ourselves and so forth to determinations and so forth, and binding decisions. We go through the commission, now we go through the court, and now the petitioner can take it up and have the court's decision reviewed with some unspecified body of law that is going to be applied. I see this as very problematic. I'm just saying, both from a political reality in terms of a state ever wanting to subject themselves, when they've already subjected themselves to a complaint procedure which has a court whose decisions are binding, and they thought that those were the ultimate thing. You've got a big political problem on your hands. And then again, as I said, the reality is, yes, there's certain things that are of the core of non-derogable rights is common to all of there's some slight differences, but we have a core of non-derogable rights in all of the civil and political treaties. You mentioned many things that are on the economic, social, and cultural area and so forth, where the enforcement mechanisms are different and so forth. It's not as immediate and so forth as we have in civil and political. So that, as I said, to me represents a very major hurdle in terms of persuading a state. And as I said, from the perspective of a victim, without having any express notion that it would award damages and so forth and so on, there is a major disincentive. I can tell you, with the kinds of cases that we've heard in the Inter-American and the Europeans and the Human Rights Committees, massacres, you name it, and disappearances, torture, if they're not going to give any kind of economic relief for that, then there's no incentive even for the petitioner to file. I'll leave it at that. Yep.
Okay, great. Let's go to Rebecca Shoot from Citizens for Global Solutions.
Hi, everyone, and greetings from Chamonix, France. I am, as David said, the executive director of CGS. I'm also the co-convener of the Washington Working Group for the International Criminal Court, and previously worked in chambers in the presidency of the ICC. And in about a week and a half, I'll be participating with Justice Richard Goldstone, Judge Mark Wolf from the Federal District of Massachusetts, in the drafting of a statute for the International Anti-Corruption Court proposal, which we see as concurrent and complementary. So I'd like to pick up a little bit on this discussion of complementarity or exhaustion of remedies. So taking the ICC as an example, which has been it has been operational for more than 20 years, the ICC is still very much navigating its own definition of complementarity, what it means to be willing and able at the domestic level to pursue justice, to investigate and to prosecute those accused or alleged of atrocity crimes within its jurisdiction. Now, the early cases, the early situations, DRC, Uganda, et cetera, it was pretty clear that there was an inability But now we've gotten to thorner territory, and there have been significant criticisms of the ICC. I'll take as one example, the UK was found to have satisfied the complementarity requirement with regards to the situation in Afghanistan, despite not having prosecuted or seriously investigated, according to civil society watchdogs, a single alleged perpetrator of war crimes in that conflict. So my question then becomes, to what degree do we define these terms, and do we define this jurisdiction, this appellate jurisdiction, at the outset as drafters? And to what degree is it for the jurists, the prosecutors, and others who are involved in the court's mechanics and working modalities to flesh those out based on their experience over time? Perhaps some would argue that this has taken far too long and is too nebulous for the amount for the tenure and the longevity of the ICC. So where's the balance to be struck for the WCHR? Thank you.
Could I just make a point? The issue of exhaustion of remedies, as I understand from Mr. Ottinger's clarification about the jurisdiction, is not concurrent, but it's would be an appeal from a decision of the highest organ within the regional system. Well, there's no problem with exhaustion, quite frankly. The individual to get a foot in the door before the commission or the court at a regional level would have had to exhaust domestic remedies. You couldn't get there, or they applied an exception. So it seems to me what you're talking about would be in the case of, let's say, it had jurisdiction over, if for some reason China miraculously were to ratify this statute, and there's not a regional system. In other words, did they exhaust domestic remedies and so forth? I think here is something where I would agree with, just like international tribunals, and indeed the former Yugoslavia, we have examples where judges looked at, for instance, on issues of duress, as whether or not it was in mitigation of punishment or was it a complete defense. They looked at a variety of common and civil law in mixed jurisdictions in order to see if they could extrapolate a general principle of law. And I think that all of the regional bodies, for instance, have similar jurisprudence on exhaustion and on exceptions there too, because look, this all comes from the law of state responsibility in ICJ practice and so forth. But as I said, if this seriously contemplates getting an appeal from the highest regional court, human rights court, the issue of exhaustion simply does not, I mean, I couldn't conceive of the fact that this Superior World Court of Human Rights would even give this 5 minutes of thought, because they would have had to exhaust in order to get their foot in the door. Yeah.
So can I just make, I'm sorry, I don't know if I'm
Mark,
muted.
yeah, no, you're not. We're over time, so make it quick, as I do have one more question for Professor Goldman.
So just one point then. So Professor Goldman, you seem to focus on cases where you have individuals or perhaps small groups of individuals that are the victims of a particular set of circumstances. You mentioned a massacre or something like that. One of the differences between the World Court of Human Rights statute as envisioned is that it would probably deal exclusively with class actions. And the analogy was made during the drafting process that if you think the US Supreme Court gets 10,000 applications per year, it chooses about 75 of the most make-weight cases, the ones that are inconsistent at the circuits, the ones that have the greatest quantitative and qualitative impact. And it is through that type of a mechanism that the World Court of Human Rights is envisioned to take on its cases. So don't think in terms of, a particular incident at a particular checkpoint. Think in terms of Gaza, think in terms of Ukraine. And for that purpose, I think the issues are big enough that the notion that, and there's an ombuds office, and there's standing for public international standing type of stuff for the international human rights or Democracy Watch, and so it was to be that kind of scale of cases, not individual cases with remedies. And that, I think, is one of the reasons why compensation or reparations were felt by the chief justices to be less important, and that they were more confident that they, as judges, thinking as judges, that they would be able to flesh out the jurisprudence more so as judges, as opposed to being given essentially commentaries and annotations by which to essentially, the judges would like to have sort of the jurisprudence evolve in the hands of judicial creators. That was their vision. So great conversation, and I'm sorry I spoke over time.
Bob, did you have any comment of that? If not, I do have one more, I think, for the coalition.
No, go ahead.
One
Let's
more-
hear
Okay.
sure, go ahead.
Sure. So you, with your, lifelong years as a litigator, an academic, a commissioner on human rights commissions, as well as an advocate, who should we go to in the halls of governmental power and in the halls of civil society, non-governmental organizations to advance this idea of a World Court of Human Rights, no matter what the final view of our statute would actually look like? Where do we go from here? What are your suggestions?
Well, you've got to certainly get buy-in from states and from different regions. And the UN system, there's regional representation in this draft statute. And so that there are the regions within the UN system. And buy-in from states that are willing to support this. But I think you're going to get pushback on the same. I think I'm just giving you things that you're going to, experience, because what Mr. Ottinger says is not that apparent from reading of the statute. What is in judges' minds is not the same thing that is written in the language. I welcome the clarification. The other thing is with NGOs, the usual suspects, Human Rights Watch, Amnesty, ICJ, they're all over. I mean, they're all over the world. These are just three of the big ones that deal with global issues. Without that kind of support, because these are the things that get the ball rolling and get something introduced or whatever. Do you want to get the imprimatur of the Human Rights Council and then eventually the General Assembly? Is this going to, there are all sorts of options. As I explained to you, we had to deal with that when, we were deciding, Francis Stang and Walter Kalin and I and so forth, whether we were going to go for a treaty on internally displaced persons or guiding principles, because blah, blah, blah. These are strategic things that, so yes, you need to have that kind of thing. But let me just clarify one thing. My notion of a commentary was to explain something, not to tie the hands of the judges. It is why jurisdiction on these matters and not other matters or so forth. I understand. Do you want to have things, a lot of things you raise on Gaza, atrocity crimes? Well, the ICC is also looking at this. And this raises, by the way, this whole thing of what governs human rights law or IHL? Are they going to be able to apply IHL? How are they going to be guided? Because the big issues in Gaza, quite frankly, are those that arise under the law of war, targeting, obligations, and so forth, where human rights law, quite frankly, in my view, it's the, sort of the lex generalis. It's not the lex specialis, unless you're dealing with custodial offenses. So something that would flush out a little bit more to explain what is the reasoning behind limiting or class actions or not. It would be helpful, because the statute doesn't read that way. I've had to get this from hearing explanations. So it's certainly, but as I said, you have your work cut out for you. And as I said, I strongly, if I were to recommend something, international law, like domestic law frequently, is made incrementally. You don't always get the whole loaf. And if you could get something that would have all at the UN system for all the treaty bodies that have complaint mechanisms, but only commissions, and then create a court that would have appellate, jurisdiction over decisions. That would, I think, not that it's without political problems, but I think that would be highly attractive to NGOs. And it's NGOs, believe me, that if they can get the support of Nordic countries or some other good guys or whatever, they can get the ball rolling. But I think, this may be over ambitious, the way it is written, and I would think some reconsideration where there is a clear-cut gap and many people perceive a gap in terms of enforcement and so forth. That would be my recommendation.
Well, yeah,
But I mean, this is something we could spend days on, and I know that, and you guys have been dealing with this for quite some time.
Yeah.
Anyways, it was a pleasure to be with you, and
Yeah, thank you.
perhaps to be continued at another time.
Exactly. Well, we'll invite you to the next several, meetings, of course, and would love your participation to give us these concerns and obstacles. And I think what you're saying is we shouldn't give up the good for the perfect, right?
Yeah.
And I love to quote Jonathan Granoff, who said that we're like building a cathedral. When you build a cathedral, it could take 400 to 600 years, right? And people who are starting it may not see the final cathedral being built, right? So that's how I think we sort of see our World Court of Human Rights as like you said, we want to help people immediately, obviously, who are suffering, but in the long run, we want to have a world that's full of peace and justice, of course. And I just want to say a final thing about our next meeting, which will be the last Wednesday of April 24th. There'll be a human rights, especially for the LGBTQ plus community, advocate, a woman named Melanie Nathan, who's from South Africa, and she'll be talking about with us about the World Court of Human Rights and how that might help people in the LGBTQ plus community. So I encourage you all to come to that event, and I will invite everyone, of course, by email to that. So Bob, once again, thank you so much for taking extra time going over the hour with us, and I look forward to speaking with you again soon.
Good. Thank you all very much for the attention. Appreciate it.
Thank you, everyone.
Thank you,
Thank you,
Bob.
Bob. Thank you, David.
Thank you.
Bye-bye.
Thanks, everybody. Take care. Bye-bye.